So, very good evening, friends. So, let us discuss some of the provisions regarding this liquidation and voluntary liquidation before we move on to case studies. Although we have discussed these provisions earlier also, but let us revise some of the important provisions and let me ask you some questions on this. So, if we go to section 33, subsection 3. This is section 33.3. Now it says where the resolution plan approved by the adjudicating authority under section 31 or under subsection 1 of 54L, which talks of prepack, is contravened by the concerned corporate debtor, any person other than the corporate debtor whose interests are prejudicially affected by such contravention may make an application to the adjudicating authority for liquidation order as referred to in subclauses 1, 2, and 3 of clause B, subsection 1. Now, please answer me this question. Suppose a resolution plan has been approved by the adjudicating authority. Okay. And now there is a contravention by the CD. Now, whether CD can file an application for liquidation or not? There was a CIRP going on against a company. Resolution plan was approved. But later on, during implementation phase, there was a contravention by the CD. Now, can CD file an application for liquidation?
No.
Yes,
No.
CD cannot file because it says any person. Yes, because he was the responsible for all this fiasco. So, other than the corporate debtor. So, other than the corporate debtor is important here. So, any person other than the corporate debtor only can file, and the corporate debtor, because of whom this contravention took place, cannot file. Now, if says on receipt of an application under subsection 3, if the adjudicating authority determines that the corporate debtor has contravened the provisions of the resolution plan, it shall pass a liquidation order as referred to in subclauses 1, 2, and 3 of clause B of subsection 1. Now, let us go to section 33, subsection 5. Section 33, subsection 5 says, subject to section 52. So, the first thing is that it has been made subject to section 52. When a liquidation order has been passed, and section 52 we know talks of the secured creditor. So it says subject to section 52, when a liquidation order has been passed, no suit or other legal proceeding shall be instituted by or against the corporate debtor. Now it says no suit or other legal proceeding shall be instituted. So there are two important things here. One is the suit or other legal proceeding. So what is the meaning of the suit or other legal proceeding? Whether income tax proceedings are covered. Suppose income tax issues them a penalty notice. So whether it will be covered or not?
Yes, covered, sir.
Acha, sales tax proceedings?
Yes, it will cover all proceedings. Sir, but you are telling moratorium should not applicable in liquidation. Should not
No, just a minute, Shankar Rao. And the land acquisition proceedings under Land Acquisition Act, they will also be covered. But another important thing is shall be instituted. So what does mean by shall be instituted? Shall be
those suit and legal proceedings already ongoing है sir, that will be continued.
Yes. जो पुरानी है मतलब नई बीमारी नहीं शुरू कर सकते, पुरानी वाली कंटिन्यू रह सकती है. शैल बी इंस्टीट्यूटेड मतलब नया नहीं शुरू करना, पुराने वाला चलेगा, पुराने वाली प्रोसीडिंग चलेगी, पुराने पर कोई बार नहीं है. ये इंपॉर्टेंट चीज है. So bar is on institution of suits or other legal proceedings. It does not bar the continuation of suits or other legal proceedings pending against the CD or filed by the CD. Okay.
Sir, arbitration also it will go simultaneously.
हाँ, मैं ऐसा है, वो कह रहा है कि भाई इंस्टीट्यूट नहीं करना है, नया नहीं शुरू करना है, पुराना जो चल रहा है, आर्बिट्रेशन भी कवर होगा, इनकम टैक्स भी कवर होगा, सेल टैक्स भी कवर होगा, लैंड एक्विजिशन भी कवर होगा, जो भी प्रोसीडिंग है सब कवर होगी।
नया नहीं हो सकता।
नया नहीं हो सकता। यस
There is a caveat, sir. That
यस
proviso
यस
says,
हाँ, नहीं प्रोवाइजो, अभी प्रोवाइजो पर आएंगे, अभी तो हम पहला लाइन डिस्कस किए, अभी सेकंड लाइन पर आएंगे। सेकंड लाइन बोलता है प्रोवाइडेड दैट ए सूट और अदर लीगल प्रोसीडिंग मे बी इंस्टीट्यूटेड बाय द लिक्विडेटर on behalf of the corporate debtor with the prior approval of the adjudicating authority.